Swayam Prabha. Digital India. Educated India.
Dear students, in this class we will discuss about the development of competition law in India, especially in the post independent scenario. And India, as you know that it is under the rule of British up to 1947, and much competitions were actually restricted, or you can say that the competition in the market was absolutely, it was not there. This was happened mainly because of the raw materials were transported to Britain in order to increase the efficiency of the British companies, rather than promoting the Indian companies at that point of time. And presently we can find provisions in the Indian constitution for promoting or promoting economic efficiency and the division of labor or division of economic, the concentration of economy is banned actually in the constitution. So, the provisions or relevant provisions which says that the state to secure a social order for the promotion of welfare of the people. So, we already talked about the welfare of consumers, and Indian constitution clearly says the welfare of the people, says that in order to achieve that objective, the state shall strive to promote the welfare of the people by the securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. So, it means that the constitution which says that it will always look into the economical and political life as well. And it says the state shall particularly look into, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities not only amongst the individuals, but also amongst groups of people residing in different areas or engaged in different vocations. So, and this is actually the reflection of the division of economic resources among the people. And especially article 39 of the Indian constitution directive principles of state policy, which clearly says that the state must take into account in particular direct its policies towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. So, it means that the material resources should be divided among the communities, so that there should not be any concentration of economy, any concentration of the economy in the market. And again it says that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. So, we could say that there is a parallelism between the objective of the antitrust law and this particular provision in the Indian constitution, which says that there should not be concentration of wealth. Actually, the enactment of the antitrust law was the concentration of wealth among the trust. So, here also in our constitution also says that there should not be concentration of wealth and the means of production should not be detrimental to the society at large. So, if you look into the scenario after post independent time, the government was going massively on the nationalization process. The nationalization process was rampant during immediately after the post independent scenario, and the government was going with planned economies through the 5-year plans. So, again, this is based on the 1956 resolution on social justice and self reliance of India. And India enacted the industrial policy in 1948, and these all nationalization and these planned economic policies were based on this industrial policy of 1948. And the government thought that the industrialization should be subject to the government regulations, because of the equal distribution of resources can happen, and which will ultimately leads to the societal welfare. And the government has given more importance to the public enterprises, and also through the nationalization process, the government want to distribute the resources among the societies at large, almost through the equal distribution which they are propounded. And also the government wants to restrict the overall economic activity. For example, even the size of the plant, the production, its location, sectors, allocation of finance, and even allocation of loans from financial institutions. And it followed a license Raj system and a high tariff walls in order to prevent the imports or intrusion of the foreign companies into the Indian market will be successfully it is prevented by high tariff walls, and there were severe foreign direct investment restrictions, and the quantitative restrictions were put on all imports. So, all these comes together, it was impossible for any foreign company to operate in the Indian market. So, the Indian market was artificially made. So, which is we would completely say that there was no competition in the Indian market. So, everything was controlled or regulated by the government through the various measures, regulatory measures. So, if we look into the competition law, and it was not an easy task to move to a competition law at that point of time. Rather, the government has enacted, we can say that the government has come out with a legislation which is more restrictive in nature, known as the Monopolies and Restrictive Trade Practices Act of 1969, which is popularly known as the MRTP Act in 1969. And the most planned economic development was happened in accordance with the Industrial Development and Regulation Act of 1951. So, it was, even though there was an industrial growth, it was completely a restricted license Raj system which was prevailed in the market until the 1990s in the Indian market. But the government was actively considered the government the various reports prepared by the experts in order to distribute, and the government thought that there should not be any concentration of economic power with few in the post independent India. So, the first such committee was is constituted, which is known as chaired by Mr. Hasari, which is popularly known as the Hasari Committee. And the Industries Development Act played a very crucial role in the development of industry. We would say that rather restricting the industrial activities at that point of time. And the committee come out with its recommendations in 1965, and the Hasari Committee have a lot of recommendations. So, the Hasari Committee studied the Indian market with two objectives, and the objectives, and they looked into or reviewed the operation of licensing under the Industries Act of 1951, and then secondly, to consider and suggest in the light of the present stage of economic development, and what should be the direction or what are the modifications to be made to the licensing policy. This is the very confined agenda of this Hasari Committee. And if you can see that what are the recommendations of this particular committee, and we know that the entire resource allocation was happened through the planning commission and the 5-year plans, and the allocation is happened through these 5-year plans and the planning commission to the different states of India at that particular point of time. And for example, the planning commission, so the committee recommended that the planning commission should come out with a plan and policy to the distinction. The committee should distinct between the conclusive targets and indicative targets as a priority areas. What should be the priority areas of investment and economic concentration, and then again regional allocation. As I already told you that if a developing country like India at that point of time or immediately after independence, the regional allocation is very important for the distribution of resources or efficient use of resources. And each plan period also the 5-year plan period also, the allocation of industries should be reviewed every 2 years. This was another recommendation of the committee. Then the most important the recommendation of the committee was that the large industrial houses should not be given licenses for capital goods industries, because this is the committee thought that this is going to be more concentration of wealth in the big industries at that point of time. That is why the committee recommended for again a curb, again there is a hurdle on licensing to the big industries at that point of time on the capital goods. And another recommendations which you can see, the access to finance. The always it is not only the post the independent scenario, even today the financial institutions always favor the large business houses, and they have an their attitude towards a small scale industries are a stepmotherly attitude. And this is the British period policy which is followed by the financial institutions in India, even though there are a lot of changes in the present days. But this is one of the recommendation of the Hazari committee at that point of time as well. And also the government should prioritize the industries and also the products, a series of products which are exclusively reserved for small industries. In the last class which we discussed about the resource allocation to the large industrial houses and a harmonization between the large industrial houses and small scale industries. This is exactly is recommended by the Hazari committee as well at that in 1965 in India. And then the major fiscal policy and the tax concessions. The tax concessions for the major industries as well as the small scale industries, and there will be tax holidays and tax rebates, and should be there is a close connectivity between the resource allocation and efficiency of the industries, which is connected with the fiscal policies. So, the fiscal policy also should promote the market and competition in the industry. And other recommendations, if we look closely into the licensing system, and and also the entrepreneurial aspect of the licensing system. So, the excessive curbs. So, the committee thought that the excessive curbs on the licensing system will reasonably assure the small scale industries to grow. If more curbs or more restrictions or regulations on big houses may leads to the promotion of small scale industries, this is the committee actually recommended. And also the cost of the products and the cost of imports. So, the committee recommended for a domestic production rather than recommended for import of most of the goods, even though it is uneconomical, because this is mainly in accordance with the policy of self reliance at that point of time. The government followed the self reliance policy at that point of time. And if you look into very closely look into, I am not going through the the specificities of the recommendation, but the committee also recommended certain exemption limits. The committee put certain exemption limits for the existence on capital equipments. So, they put certain restrictions on the capital equipments and also the project management. And we can see that this is the committee first committee recommendations which led nowhere else. And the second committee was recommended in the constituted in 1964. So, it was in even though it was set up parallelly set up in 1960. So, this was basically and mainly concentrated on the level of income disparity in the country. So, the committee was constituted in 1964 and mostly you can see that presented to the India. So, the committee found that the wealth, the entire wealth in the country was in the top 10% of the population. And I do not think the scenario has been changed so far, and still the billionaires or the wealth in India is with the top 10% of the population. and the 40% of the income was with the 10% of the population at that point of time, and now it is much more. And this is actually this committee was known as the Monopolies Enquiry Commission. So, was constituted the commission was headed by Justice K.C. Dasgupta at that point of time. So, this was popularly known as the Dasgupta Commission at that point of time. So, here you can see that basically this committee was looking to the economic power of product wise or industry wise concentration. The committee specifically looked into the economic power in the form of product wise and industry wise concentration. And also the committee noted that the industrial houses, which are those industrial houses controlling the large number of companies, and also the large scale restrictive and monopolistic activities of these particular companies. So, the committee looked basically into the large business houses and their behavioral aspects, which compelled the committee to look into, mainly because of even though there was policies for the distribution of resources, ultimately it looked into the trust aspect which was in the United States. The similar aspect was came into prevailing at that point of time in India as well. So, the committee was given this particular task. So, this particular committee come out with a particular bill which is recommended for the control of monopolies as well as the prohibition of monopolistic and restrictive activities of these big companies, which is prejudicial to public interest. So, definitely there is a close similarity or a parallelism between the Trust Act at that point of time, the Antitrust Act, and this proposed legislation at this point of time to control the monopolies and also the monopolistic activities, not only monopolies, the monopolistic activities or restrictive trade practices of companies, big business houses at that point of time. The monopolistic practices which were pointed out by this committee are every practice. So, whether it is by action or understanding or agreement between companies, or whether it is a formal agreement or informal agreement, or persons enjoying monopoly powers resource to exercise the same to reap maximum benefits or to have a power in the market, and also understanding or agreement tending to calculate to preserve, increase or consolidated power to exploit that particular market. This will be considered as the monopolistic practices. And also if you look into the two types of practices, one is the monopolistic practices and second is the restrictive trade practices. And the restrictive practices, which you can see that there are a series of restrictive practices generally adopted by these particular companies in preventing, distorting or restricting competition. And this particular, there is a series of activities which you can find it in the form of refusal to trade, tie up sales, tie up agreements or tying up of products, and then the forcing, full line of forcing, then exclusive dealing agreements, then concerted practice, then price discrimination, then resale price maintenance, then area wise, that is the territorial restrictions or area restrictions, then discriminatory pricings. All these are considered as restrictive trade practices by the commission at that point of time. And you can see that ultimately this committee was successful in drafting a bill, as well as the government is enacted this converted into the law in the form of Monopolies and Restrictive Trade Practices Act of 1969, which is popularly known as the MRTP Act, which came into existence from 1970 onwards. And remember, this act is in it is in, we would say that in power for a long period of time, and its objective was, and this is nothing to do with promote competition, but to restrict the monopolies and restrict the trade practices, restrictive trade practices. And monopolistic effect if we look into, and you can see that it's a monopolistic effects are always a disadvantage to the weaker sections of business, especially the small scale industries. And we know that these monopolies basically absorb the small companies and they become giants. and it may leads to the monopoly, and this leads to an economic disparity due to the concentration of this economic power. This monopoly basically leads to the growth of inequalities in the market, and also the power balances in the system increases, and this power imbalance which leads to corrupt practices or restrictive practices, and these corrupt practices which can influence the economic policies of the governments at that particular point of time. And also as you can see that the monopolistic or oligopolistic activities are always responsible for is misdirection of resources, and this also happens mainly to control the power as well as to control the market by these particular companies. And the MRTP Act, this particular objective of the Act to ensure the operation of the economic system does not result in concentration of economic power in hands of few. It clearly says that there should not be concentration of economic power, and to provide for control of monopolies, and making monopolies is not illegal, but the activities of monopolistic activities, when it prohibit or prohibitive activities or when it affects the market, then this is to be controlled actually. Then the prohibiting monopolistic and restrictive trade practices also was one of the objective of the MRTP Act. If you look into the unfair trade practices, and they made an amendment in 1984 to include unfair trade practices. So, as you know that we already talked about when the Sherman Act came, the companies want to avoid the provisions of the Sherman Act, and they are gone for mergers, and then the Clayton Act was passed in order to amend or to come out with to curb the loopholes in the Antitrust Act. Here which you know that they come out with an act for curbing the monopolistic activities, then the company is gone for unfair trade practices. So, they are forced to come out with amendment in 1984. So, these we can see that there are many activities which were considered as unfair trade practices, which impose falsely suggests that services are of a particular standard, quality, quantity, grade, and again falsely suggesting rebuilt, second hand, renovated, reconditioned. So, the representation of goods and services, sponsorship of performance characteristics, accessories. So, you can see a bundle of unfair trade practices which were mentioned in the particular act, and again seller so the unholy relationship between the sellers and suppliers, and then is again false or misleading representation concerning need for the usefulness of goods and services. And then again there is the unfair trade practices in guarantee and warranties of products and performances, and this efficacy of product, their length of life, and there is misrepresentation on the goods and without adequate or proper test. Then again representation to the publics, misrepresentation to the public, and warranties and guarantees, then promises and promise of replacement and repair of goods. All of these will come under the purview of unfair trade practices. And then unfair trade practices again, which you can say mostly which is misleading in nature, and mostly misleading in nature, misleading about the prices, misleading about the warranties and guarantees, misleading about the services, and misleading about the goods and services of, and you can see that mostly which is unfair practices. I would say that all these will be considered as illegal practices. Then monopolistic practices, what is the effect of these monopolistic practices? And we know that all these monopolistic practices which is concentrating towards the which preventing the efficient allocation of resources towards more favorable to the big business houses and disadvantage to the small business people. So, all these, that is why these practices will be considered as monopolistic practices. And then again there is a close connectivity between the the market allocation as well as the production, the prices, price maintenance and the cost of production. So, as you know that we already said that the small scale industries allocate resources very less, so their cost of production will be more than when compared to the big business houses. The big business houses allocate more resources, so their production cost will be very less. So, the prices, the sale prices will be there will be a disparity between the sale prices of big business houses and the small business houses. So, this should be a balanced. So, the profit of big business production houses will be very high, and if these big business can control the supply chain also and supply and distribution of goods and services, then there will be more profit and which will be much disadvantage to the small business small business people, in the sense that the small business small scale industries especially. And we call it unfair trade practice, because these trade practices are the purpose of promoting sale, any kind of promotion of sales which is related to the supply of goods, warranties, and then unfair method or deceptive practices, whether it is the warranties which is oral in nature or written or visible representation, all these will come under the purview of unfair trade practice. Then you can see that in 1978 so Justice Rajendra Singh Sachar was appointed as one committee to study the report in 1978. The committee submitted this report in 1978, and here you can see that there was no consumer welfare provision at all at that point of time, and then so all false or misleading representations, mainly the restrictive trade practices at that point of time. And then 1991, which you can find these amendments. So, especially which we talked about why these amendments were necessary in order to open the economy in 1991 in India. So, the liberalization or globalization, or which we talked about, the opening up of economy, liberal economies, which mandated, which become necessity to open our amend our competition policies. So, and also we saw that these the act, the Monopolies and Restrictive Trade Practices Act was not contributing to this competition in the market, rather go for more and more cartelizations, collusions and price fixing and abuse of dominance. And also more importantly, there will be bid rigging and predatory pricing, which was happened under the MRTP Act. So, we can see that because of the 1991 opening of economy, which was I would say that which was compelled or facilitated by the at that point of time by the IMF conditionalities, because it is India faced at that point of time due to the crunch, the foreign at that point of time, mainly due to the so India compelled to take the IMF loan due to the balance of payment problems at that point of time, and which compelled India to end the license Raj system in 1991. So, whole the conditionalities of the IMF, which compelled India to take away the license Raj system and abolition of levy, and the entire market has made a transformation due to these IMF conditionalities, and also to remove the hurdles in doing business in India, like quantitative restrictions and preferential treatment to the domestic industry, and also restrictions on the foreign direct investment, and the government was compelled to take away all these restrictions in the Indian market. And there was no other choice for India to come out with a competition law at that point of time, and at that point of time the Singapore Ministerial Declaration, of is the WTO Ministerial Conference. WTO Ministerial Conference in Singapore come out with a declaration in 1996, which emphasized on competition law in each and every country, and the Union government has set up a committee in 1997 to study the Indian scenario at that point of time. So, basically the interaction between the trade and competition policy, and also the anti-competitive practices, mergers and acquisitions and competition, and identifying this basically within the framework of the WTO, which compelled the India to appoint an expert group in 1999, which is and which come out with the recommendations. And in 1999, which was famously known as the Rahman Committee, was appointed to study on the Indian market and to come out with a competition law in the country. So, this is mainly on the background of there are many cases. There are many cases, as well as India became a founding member of the WTO, which compelled India to come out with the changes in the policies, like India amended its all intellectual property laws, and most of the legislations India was compelled to amend. And moreover, India faced with WTO cases like Indian agriculture case, India was forced to eliminate all quantitative restrictions. India was forced to amend its intellectual property laws. India was forced to change its investment policies in the auto case. So, all these combined together India to think of a competition law. And finally, and ultimately we can the committee come out with a bill which is in the form of all competition provisions like any other developed country, and more parallelism which you can find it in the European Union, which we will study in our other modules of our class. And you can find after even enacting after 2002, the act was not operational, mainly because of some of the disputes which was continuing in the different courts in India. And you can find some of the very recent amendments in 2018 on the combinations, the business relating to combinations, which made the Indian Competition Act. We will study about the Indian Competition Act in detail in the coming classes. And I would say that the journey from 1950 to 2002 was turbulent, and India was changed from monopolistic and restrictive activities towards competition in the market, and India enacted the Competition Act in 2002, and which was operational from a later stage, and which compelled India to a competitive economy and to adopt the competition policies in the market. In the next class, we will talk about in detail about the act as well as the different policies which are adopted by India. Thank you.